Good afternoon, everybody. Welcome to No Opinion. I'm your host, Terrell Hussein, and there's been a lot of movement in the case in Washington, D.C. with Donald Trump and Jack Smith in reference to the January 6th event. As you know, Jack has filed a motion for protection, and Trump's team had until 5 o'clock today to respond. And that's what we're going to be covering, is the response by Donald J. Trump's team of lawyers. Now, I'm going to add here, this one is different. I've been reading a few of these, and this is the first one I've ever seen that has had such a large section for notes underneath, for footnotes. So that's kind of new to me, and I don't cover the footnotes. I just read the body of the document, and I try to minimize the actual, the numbers, to try to help it be more clear. So with that, we're going to get started on this, and let's roll. United States of America versus Donald J. Trump, defendant. Response in opposition for government's motion for a protective order. President Donald J. Trump, through counsel, submits this response in opposition to the government's motion for a protective order. Docs 10-10-1, motion and proposed order. Introduction. Fed R. Crim P. 16 allows the court to enter protective orders limiting the use of sensitive discovery material that presents particularly discovery materials presented particularized safety or security concerns instead of hewing to the narrow framework the government requests. The courts restrict all documents produced by the government regardless of sensitivity, contrary to established law and President Trump's First Amendment rights. To resolve this issue, President Trump respectfully requests the court adopt the attached red line, example A, the proposed red line, which narrows the proposed order to shield only genuinely sensitive materials from public view. This more measured approach is consistent with other protective orders entered by this court in cases concerning the events of January 6, 2021, and appropriately balances the government's claimed desire to protect highly sensitive categories of material and expedite the flow of discovery. Motion at 3, with the rights of President Trump and the public to free speech and an open proceeding. Additionally, the proposed red line addresses several important definitional and procedural issues. The parties have reached agreement on a small number of these revisions, as indicated in the proposed red line. We discuss certain additional revisions in Section B below. Finally, to the extent the court overrules President Trump's objection to restricting the use of non-sensitive documents produced by the government, we attach an alternative red line, example B, that removes edits directed to this issue while retaining all other proposed revisions. Argument A. The proposed order is overboard. In a trial of First Amendment rights, the government seeks to restrict First Amendment rights. Worse, it does so against its administration's primary political opponent during an election season in which the administration, prominent party members, and media allies have campaigned on the indictment and proliferated its false allegations. See press release, special counsel. Now, as you see, there's going to be a lot of notes in here. I'm going to skip over these notes to continue on to the actual statement. Jack Smith delivers statement August 1st, 2023. Gratuitous out-of-court statements to media regarding allegations in this case. Schumer-Jeffries joint statement on the federal indictment of Donald Trump related to the events on January 6, August 1st, 2023, repeating allegations and claiming President Trump engaged in a criminal plot. Glenn Kirshner, why this Trump indictment is the most important. MSNBC, August 1st, 2023, falsely claiming, based on this case, that President Trump attempted to end our representative democracy altogether. President Biden likewise capitalized on the indictment, posting a thinly veiled reference to his administration's prosecution of President Trump just hours before the arraignment. Displayed is a picture of Joe Biden drinking from a coffee cup with the statement of "A cup of Joe never tasted better." There's a link for Twitter, last accessed August 6, 2023. See also when Kevin Tan, Joe Biden appeared to throw major shade at a thrice indicted Trump with the new dark branded meme, and Twitter loved it. Business Insider, August 3rd, 2023. Indeed, President Biden promised from the outset that his administration would ensure President Trump does not become the president again. Adding an unprecedented political dimension to this prosecution, remarks by President Biden in press conference November 9th. Moreover, the Biden Justice Department waited over 2.5 years to seek this indictment during an election cycle in which President Trump is the leading candidate. Against this backdrop, the government requests the court assume the role of censor and impose content-based regulations on President Trump's political speech that will forbid him from publicly discussing or disclosing all non-public documents produced by the government, including both purportedly sensitive materials, proposed order at 8, and non-sensitive, potentially exculpatory documents, proposed order at 1, restricting all materials provided by the United States in preparation for or in connection with any stage of this case. This untargeted method offends both the First Amendment, which requires a compelling government interest, and narrow tailoring to justify the prior restraint, pursuing AM's Greatness vs. Fed Election Com 363 F Supplement 3D 94 100, and Rule 16, which places no express limit on the purpose for which discoverable material can be used. United States v. Johnson. With respects to speech, the First Amendment has its fullest, most urgent application precisely to the conduct of campaigns for political office, and the restriction on political speech that does not avoid unnecessarily abridged of First Amendment rights cannot survive rigorous review. McClutchan v. Fed Election Com. Thus, to the extent the government seeks to restrain President Trump's ability to speak about documents it produced, it must demonstrate compelling reason for the restraint, that no narrower alternative is available. Here, President Trump does not contest the government-claimed interest in restricting some documents it must produce, such as those containing Rule 49.1 information and Rule 6, grand jury materials. However, the need to protect that information does not require a blanket gag order over all documents produced by the government. Rather, the court can and should limit its protective order to genuinely sensitive materials, a less restrictive alternative that would satisfy any government interest in confidentiality while preserving the First Amendment rights of President Trump and the public. CF pursuing AM Greatness 363 F Sup 3D at 100. When a plausible, less restrictive alternative is offered to a content-based speech restriction, it is the government's obligation to prove that the alternative will be ineffective to achieve its goal. The government must present more than anecdotal and suppositional to support its regulation subject to strict scrutiny, citations and quotation marks omitted. The government does not and cannot explain why this protocol would be insufficient. It can easily designate the subset of documents it believes are sensitive and has apparently already done so. See Doc 10.1 at 8, confirming the government will identify sensitive documents prior to discovery or concurrent with disclosure. Doc 12 at 2, advising the government is ready to press send on all discovery production, which presumably includes the promised designations. Nor does this district regularly prevent the disclosure of non-sensitive documents, as the government suggests. Motion at 3. Just the opposite. The court recognizes that a protective order should be limited to documents implicating that the safety of the witness and others, a particularly danger of perjury or witness intimidation, and the protection of information vital to national security. Johnson 314 sub 3D. At all times, the burden of showing good cause for blocking the disclosure or use of documents lies squarely on the government, which must make a particularized showing of the need to protect the document at issue. ID at 253, citation omitted. See also ID at 251. Ordinarily, broad allegations of harm, unsubstantiated by specific examples or articulated reasoning, do not support a good cause showing. Citation omitted. Here again, the government does not explain how the existence of some potentially sensitive materials present a good cause for the closure of all non-public materials it produces. Regardless of sensitivity, instead, the government states that here good cause exists because issuance of the government's proposed order would expedite the flow of discovery in this case, give the defendant prompt access to a large portion of the discovery he ultimately will receive, and protect the highly sensitive categories of material described above. Motion at 3. But, as noted above, the government has apparently already identified the documents it believes are sensitive, at least with respect to the first production, meaning that restricting non-designated documents would provide no benefit to the flow of production. Likewise, even if such benefits existed, and they do not, it would not justify indefinite closure of non-designated documents. At most, it would console only a brief period of closure to allow government time to make designations, which would be subject to challenge. But because the government sensitivity designations appear substantially complete, any closure based on efficiency is unnecessary. Finally, it is axiomatic that the government claims need to protect highly sensitive categories of material cannot support restrictions on non-sensitive materials. According to President Trump's respectful request, the court adopt the proposed red line, Exhibit A, which removes proposed order general restrictions on all materials provided by the United States, while maintaining restrictions on sensitive materials. This tracks the protective order entered in other January 6 prosecutions, which the court similarly limits to sensitive material. See United States v. Sidney Young. Protecting only sensitive or highly sensitive materials in enumerated categories and stating that government agrees to make every effort to provide discovery in a manner that will allow for discovery to be produced without such designations. B. Other disputed revisions. Despite the extraordinarily limited time President Trump had to prepare this response, we attempted to confer with the government in good faith over the weekend by sending our proposed revisions and arranging multiple phone calls, setting aside our general disputes regarding the treatment of non-sensitive documents. We had hoped the government would engage with us in a collaborative dialogue aimed at fashioning mutually agreeable language for numerous procedural and definitional clauses in the proposed order. Unfortunately, the government declined a cooperative approach, refusing to provide any real-time feedback. Ultimately, just hours before our deadline, the government notified Defense Counsel it would oppose most of our revisions. Example C, correspondence. Although time limitation prevents us from fully explicating Although time limitation prevents us from fully explicating every proposed edit, we address several significant issues below. Once again, we believe it would be beneficial to set a hearing on this matter, such that the parties may fully discuss each red line in sequence and address any concerns the court may have. 1. Definition of authorized person. The government requests that the court limit disclosure to materials to only certain members of the defense team. 1. Defense counsel, which it defines as counsel of record in this matter. And 2. Persons employed by defense counsel. Proposed orders at 3 and 9. This limitation is unreasonable and unworkable and not supported by any legitimate interest. Defense counsel may choose to bring on, for instance, volunteer attorneys or others without paid employment arrangements to assist with the preparation of this case. The government cannot preclude the assistance of those individuals, nor should President Trump be required to seek permission from the court before any such individual assists the defense. Such a limitation or requirement would unduly burden President Trump and impede its efficient preparation of his defense. Indeed, the defense cannot predict its future needs for this case, especially for a case of this magnitude and complexity. Nor would allowing volunteers access to discovery appreciably increase the risk of improper disclosure, as 1. Prior to any disclosure, defense counsel would still be required to provide all authorized persons a copy of the applicable protective order and obtain their agreement to abide by its term. Proposed red line at 5 and 2 sensitive materials will remain in the custody and control of defense counsel. Proposed red line at 10. Accordingly, we propose the following red line, which provides more clarity to the definition of authorized persons. Proposed red line at number 3. 3. The defendant and defense counsel shall not disclose the sensitive material of their contents directly or indirectly to any persons or entity other than persons assisting the defense, defined as including any attorneys, investigators, paralegals, support staff, consultants, or expert witnesses who are advising or assisting defense counsel. The persons to whom the sensitive information solely and directly pertains, and the person's counsel, and other persons to whom the court may authorize disclosure, collectively authorized persons. 2. Definition of sensitive materials, marking of sensitive materials. The proposed red line adjusts the definition of sensitive materials to exclude certain documents obtained outside the grand jury process. The government objects to this revision as defining too narrowly the categories of sensitive information. But as explained above, these red lines are consistent with the law and the routine practice of courts in this district, including other January 6 related protective orders that do not impose blanket restrictions on non-grand jury materials. See Cindy Young, 123. The government has not and cannot articulate such materials. Example, the government interviewed reports that fall outside the other categories above should be protected from disclosure in the same manner as grand jury materials. Moreover, the government declines without comment President Trump's reasonable request that it conspicuously marks the documents it designates as sensitive, such that the defense may easily identify those documents and prevent inadvertent disclosure. Again, the government has not articulated why it cannot apply such markings. The proposed red line solves these issues in paragraph 8. The United States designates the following materials it produces to defense counsel as sensitive materials. A. Materials containing personally identifying information as identified in Federal Rule of Criminal Procedure 49.1. B. Rule 6 materials including grand jury subpoena returns, witness testimonies, and related exhibits presented to the grand jury. C. Materials obtained through sealed search warrants 2703D orders. D, sealed orders obtained by the government's filter team related to this case. And regarding the government's confidential sources or which may jeopardize witness security. The government shall indicate which materials constitute sensitive materials prior to the concurrent with disclosure and will conspicuously mark all such sensitive materials. 3. Procedure for use of sensitive materials in court. The government appears to likely to designate a large portion of the materials produced in this matter as sensitive. Although President Trump reserves the right to object to those designations, many files, such as grand jury transcripts, will doubtlessly stand as the most relevant and significant documents in this case. Documents that will feature prominently in innumerable motions, hearings, and throughout trial. Despite this, the government seeks to obstruct President Trump's defense by requiring that he move to seal every single time he wishes to cite a sensitive designated material, whether in response to a motion, during a hearing, or at trial. Proposed Order 11.2, without question. President Trump agrees that at least prior to trial, documents designated as sensitive should not be filed on the public docket unless and until the designation is removed. So then President Trump proposed a more streamlined approach, wherein designated documents could be filed under seal without leave, subject to the party's motion to unseal. Proposed red line. 11. The parties may include designated sensitive material in any public filing without leave of court if all sensitive information is redacted. The parties may further file unredacted copies of any such designated sensitive material under seal without further order of the court. Parties may object to the sealing of sensitive materials by appropriate motion. Similarly, President Trump proposed clearer procedures for handling designated documents at hearings, while deferring any decision on trial procedures until this case approaches trial. Proposed red line. 12. During any hearing, parties may introduce designated sensitive material without leave of court if all sensitive information is redacted. The parties may further introduce unredacted copies of such designated sensitive materials or discuss such materials on the record, provided, however, the introducing party must alert the court that the party intends to introduce the material and requests the record be sealed. Parties may object to the sealing of sensitive material by appropriate motion. 13. Handling of designated sensitive materials at the trial of this matter will be decided by the court in a further order. These proposals would ensure designated documents remain closed from public view, as both proposed protective orders contemplate, while minimizing the administrative burden imposed on President Trump and the court. Yet the government rejected the edits out of hand. Why? They do not say. Example C. But what explanation could the government have? Initial sensitivity designations are its decision under the proposed order and the proposed red line, and are supposed to reflect the government's view that public disclosure of marked documents would be harmful. Thus, the government could not reasonably object to sealing such documents. Without any reason to oppose sealing, the government has no reason to demand motion practice on the topic. Instead, its position appears calculated to increase complexity while impeding President Trump's ability to litigate this matter. This is improper and should be denied. Conclusion. For the foregoing reason, President Trump respectfully requests the court adopt the proposed red line, dated August 7th, 2023, Todd Blanche, Esquire, PHV pending. The rest of this document is what he's talking about, the proposed red lines, is the revisions that he would like to see be made, and essentially what is the rulings of how this court is going to be ran. And I have to say, this is a very well thought out argument. They covered all their bases, and looks really good. On the surface, it looks great to me. And again, if you like this kind of material and you just want to hear the facts without any opinions, like I say, the only opinion I have is that the writing of the document looks good, and it's good, man. It's like, it's solid. If you like this kind of content, please subscribe, add your comments, let me know what I can do to improve it, or what it is that you're looking for out of this. So I'm going to keep reading them because this is the real news. I do not need people's opinions of what they think they're going to do and why they think they're going to do it. I just want to know what they're doing. And as far as I'm concerned, these documents are scoreboard, and the score is the only thing that matters. All that other stuff is superfluous. This is No Opinion. My name is Terrell Hussein. See you next time.